Yeah. Mr. President, I ask unanimous consent to enter into a colloquy with the junior senator from Utah and the junior senator from Nebraska.
Without objection.
Mr. President, I've come to the floor several times over the past 8 years to discuss the constitutional principle of separation of powers between legislative, executive, and judicial branch. President Obama promised that he would act independently of Congress where he had to. His quote, "Where they won't act, I will." I've come to the floor to discuss the many examples of executive overreach that we've witnessed, from unilateral pursuit of climate change regulations to unconstitutionally recessed appointments. As I've said before, the structure of our Constitution is a critical safeguard of our liberty. As Justice Scalia famously said, quote, "Every banana republic in the world has a Bill of Rights. Every president for life has a Bill of Rights. The real key to the distinctiveness of America is the structure of our government," end of quote. Now, I've served in the Senate for 36 years, so I have a deep appreciation of the different roles of the coordinate branches and for the fact that the people govern themselves through their elected representatives. And my accountability to them is the defining characteristic of my role as one of their representatives in the United States Senate. That's not true of judges in our federal system who are not elected. And it's certainly not true of the executive agencies that administer the laws that we write here in the Congress. Judge Gorsuch is the President's nominee to serve as the next Justice of the Supreme Court. And it seems to me that he really understands the important differences in these roles. Reflecting on the legacy of Justice Scalia, he remarked that, quote, "The great project of Justice Scalia's career was to remind us of the differences between judges and legislators," end of quote. So I'm now going to turn to Senator Lee, and I'd like to have him discuss a question I put before him. How do you understand Judge Gorsuch's to view differences between judges, legislators, and the executive under our Constitution?
Thank you, Senator Grassley. You know, your question really cuts to the heart of the issue. It cuts to the heart of the very reasons why we have an independent judiciary, and exactly why it is that our system of government that operates under the United States Constitution depends so critically on individuals just like Judge Gorsuch. It depends on people like Judge Gorsuch sitting on the federal bench. There are, I believe, two fundamental differences between the judiciary on the one hand and the two political branches on the other hand. That is, the two branches in which people serve after being elected to office, meaning the legislative branch, where we work, and the executive branch, headed by the president. First, the legislative and executive powers sweep far more broadly than does the judicial power. Article 1 enumerates a list of lawmaking powers that are granted to Congress, and Article 2 vests executive power in the president. By comparison, the judiciary's power is far more circumscribed. It's far more limited. The judiciary has the power to decide only a limited and defined set of disputes, those that qualify as cases and controversies under Article 3 of the Constitution. To be clear, in the context of deciding a particular case, the judiciary has the power to invalidate an act put in place by the elected branches of government. The power to say what the law is, as Chief Justice John Marshall explained in the landmark case Marbury versus Madison. But that power is limited. It's limited, among other things, by Article 3 of the Constitution and by jurisdictional requirements like standing and mootness and ripeness, as explained in greater detail by Supreme Court precedent. The judiciary's authority to say what the law is points to the second major difference between the courts on the one hand and the political branches on the other. While the function of the judiciary is an exercise in reasoned judgment, the functions of the executive and legislative branches are exercises of power. There are many ways in which the Constitution and the political theory underlying it limit the exercise of that power. The Constitution protects minority rights, and it conditions the exercise of legislative or executive power on winning elections. And that, in turn, means winning the trust of the American people, of the voters throughout the country. These twin ideas, the consent of the governed and the protection of minority rights within an essentially majority rule system, are pillars of our constitutional order. But make no mistake, coercion underlies the laws that we make in this body and their enforcement by the executive branch. By contrast, the judicial function is ultimately an exercise in reasoned judgment. As Alexander Hamilton explained in Federalist 78, quote, "Neither force nor will, but merely judgment are exercised by the judiciary." This is the essential difference between the judiciary and the other branches. The judiciary exercises judgment, while the rest of us exercise will. The framers, of course, understood this well, and as Hamilton continued in his explanation in Federalist 78, quote, "Courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. The observation, if it prove anything, would prove that there ought to be no judges distinct from that body," close quote. Put another way, a judge who chooses to exercise will instead of judgment is no longer acting as a judge. That person is instead functioning essentially as a super legislator. It should be clear to all fair-minded people that Judge Gorsuch is someone, and has established himself as someone, who understands these distinctive features of the federal judiciary. When you read his opinions, you see that his only agenda is to understand the governing law and then to apply that law to the set of facts in the case before him. As we'll see next week during his confirmation hearings, his opinions carefully analyze the statutes and applicable precedent to determine the outcome of each and every case. In some cases, that means Judge Gorsuch reaches results that Senator Gorsuch or President Gorsuch or King Gorsuch probably wouldn't choose were he deciding cases in any of those capacities. But Judge Gorsuch understands, of course, that he is a judge and not a king and not a president, not a senator, not a congressman. And he understands that this means that his only job is to adjudicate cases based on the law, according to the facts before him. As he said the night he was nominated, quote, "A judge who likes every outcome he reaches is very likely a bad judge, stretching for results he prefers rather than those the laws demand," close quote. When you examine his record, you see that one of the defining characteristics of Judge Gorsuch is his independence, his judicial independence, his independence that is distinctively the hallmark of a good judge. You see that he decides cases based on the law, not based on the parties before him, and not based on his own political or ideological preferences. In the coming weeks, some of our colleagues may try to argue that Judge Gorsuch hasn't done enough to prove his independence since being nominated to the Supreme Court. If this criticism is raised against him, it'll be a weak one. It'll be one that doesn't apply here. The fact is that Judge Gorsuch has spent his entire career as a judge and as a lawyer before that, proving his independence. To his would-be critics, I'd simply say, read and analyze his opinions. They speak for him. They speak for themselves. They speak for the rule of law. Study his approach to judging. Listen to what he says about judicial independence. And just as importantly, look at his actions. His actions prove his independence. I've done these things. I've examined Judge Gorsuch's record. And on that basis, I'm confident that he will not hesitate to apply the law appropriately in every case. There's absolutely no reason that I can find anywhere in his record to prove otherwise. I think I've only scratched the surface here today. But I look forward to hearing Judge Gorsuch's testimony before the Judiciary Committee next week.
I thank you, Senator Lee, for your very thoughtful explanation. And I know both as a senator and a lawyer, you take the study of constitutional law very seriously. And your point of view ought to be seen as an authority on the separation of powers particularly. And I think the way you see Judge Gorsuch is similar to what I do, but you know the law a lot better than I do. It's clear that the questions about separation of power can arise in a very complex and legal technical cases in the courts, but I think the principle is a fundamental one. Judge Gorsuch has made this point himself, and I'd like to quote a little of what he said. Recent Supreme Court cases, starting the quote, permit executive bureaucracies to swallow huge amounts of core judicial and legislative power and concentrate federal power in a way that seems more than a little difficult to square with the Constitution of the framers' design, end of quote. But to quote again, on the role of the prosecutor and the role of Congress, he said, quote, if the separation of powers means anything, it must mean that the prosecutor isn't allowed to define the crimes that he gets to enforce, end of quote. So I want to ask my other colleague here for this colloquy, the senator from Nebraska, a question that I'm sure he can answer and thought about a lot. These are not just legal technicalities that we're talking about, but the very fabric of our Constitution. I hope you would agree.
Hear, hear. Thank you, Chairman Grassley, for that question and for the invitation to join you in this colloquy as two of the only non-attorneys on the Judiciary Committee. It is important that we, on behalf of the majority of Americans who are non-lawyers, do reclaim the separation of powers as a basic American inheritance. And so I thank you for the chance to discuss it with you here today. Starting the morning after President Trump's victory last November, there's actually been something of a renaissance of separation of powers talk among many folks around this body. And that's a good thing. After 8 years of legislative atrophy, many on the other side of the aisle are now remembering the old schoolhouse rock distinction among the three separate and co-equal branches. And this is good news for America's civic health. If Democrats are serious, and frankly, if all of us are serious, for we in this body have taken an oath not to a political party, but to a constitutional structure of limits where power is intentionally separated and divided because our forefathers and foremothers were skeptical of the consolidation of power. If we take this oath seriously, then we would like to reclaim some of the Congress's responsibility and ability and authority to check and balance the other two branches. And the debate around Judge Gorsuch's nomination and the hearings that we'll have beginning in your committee next Monday are a great place to start. So I'd like to offer a little bit of what I think is an important historical backdrop for this debate. Any discussion of the separation of powers must be rooted in a solid understanding of what we mean by the phrase and what our founders meant by the phrase, the consent of the governed. Historically speaking, this is still a bold idea that must be constantly defined and reclaimed and renewed and passed on to the next generation. For over the course of human history, you can put every form of government into one of two categories. You're either ruled by people that you didn't choose or by people that you did choose. One of these groups has taken many forms through the centuries: kings, elites, political parties, and technocrats. Indeed, most governments throughout human history fit this mold, where the people were ruled by a form of government that they had no say in and that they didn't choose. But there's another group, and these are people who rule themselves through the leaders that they have chosen and continually get to choose. When the leaders fail to serve the will of the people, those leaders can be removed. And this describes our form of government, and it's a historical anomaly. We should recognize that, and our kids should understand what a special blessing it is to live under this form of government. The point is elegantly simple. Either people are ruled, or the people are ultimately and fundamentally the rulers. Why does this matter? This isn't a question to take flippantly, but rather each generation of Americans should re-examine and reclaim and reteach it. So why is it so important that the people are actually the rulers in their government? It comes down to a profound truth about human dignity. Human beings cannot thrive when they are stripped of basic liberties. Human flourishing requires the freedom to make basic choices about how you will live your life in community. Who are your friends? Who will you marry? Where will you work? What do you believe? Who do you worship? How do you worship? These are the things the founders meant when they said that we are all born with a right to life, to liberty, and to the pursuit of happiness. Notice that the founders were not referring to life, liberty, and the pursuit of happiness as a bunch of vague platitudes or as aspirational pleasantries for a bumper sticker. They were talking about rights. These are not given to us by any other man or woman. There are rights we have from God via nature, and so they can't be taken away from us from some other mere man or woman. Here's what's great about this idea. We're all born equals in the eyes of God and history, and we have certain rights. And as a group of equals, it requires people to get permission to serve for a limited time as our rulers. This equality is what the founders called the self-evident truth. Something so obvious that it didn't need to be proven. A truth so true that denying it would be denying something essential and true about human nature itself. And once we understand this, our expectations of our government begin to change. We expect responsiveness and transparency. We expect equality before the law. Government's primary purpose is not to solve every human problem, like a king or some all-powerful technocrat. Rather, the government's job is to provide a framework for ordered liberty so that we can live our lives in our communities and in our families, in our businesses, and our places of worship. Government's job is to secure the rights of a free and sovereign people. Well, what does this have to do with Judge Gorsuch? What does it have to do with a confirmation hearing for the Supreme Court next week? What does it have to do with separation of powers? As Americans, we secure our rights by separating the functions of government into what our founders called the three different departments. There is a Congress to write the laws. This is Article 1 of the Constitution. There is a president, or a presiding officer, as he was first called, to execute the laws. And there is a court to decide the controversies under the law. This system of checks and balances keeps too much power from falling into any one set of hands, and it keeps the American people in charge. We sometimes talk euphemistically about judicial activism, and that's a big problem, but we don't unpack it enough. A judge who takes it as his or her job to do anything other than settle cases is not just being an activist, they're becoming an untouchable, unfireable ruler. They're becoming a lawmaker that is not accountable to the people because our judges have lifetime tenure. A judge who uses his or her position to write the law fundamentally undermines the foundation of government, which is that the will of the people should rule. And this is why I'm so strongly supporting Judge Neil Gorsuch to be the next justice on the U.S. Supreme Court. He fully understands the place in the government and his place in the government as a servant of the people, not as some unchosen ruler with lifetime tenure. When you listen to Judge Gorsuch, when you read his speeches, when you read his opinions, it's clear that he is not interested in making laws. He knows that that's not his calling. He's interested in interpreting laws. He's interested in upholding and defending the Constitution. He is not interested, when he has his robe on, in specific policy outcomes. He's interested in justice. He's not interested in the laws that he as a private citizen might want. He's focused on the laws that are actually written in the books. He is a judge's judge, and that's exactly what the Constitution calls for. In closing, I'd like to read 3 quotes from Judge Gorsuch into the record to demonstrate how he conceives of his job. First, quote, "Tonight, I would like to suggest that perhaps the greatest project of Justice Scalia's entire career, again, this is Judge Gorsuch paying tribute to Justice Scalia, I would like to suggest that perhaps the greatest project of Justice Scalia's entire career was to, quote, remind us of the differences between judges and legislators, to remind us that legislators may appeal to their own moral convictions. They may appeal to claims about social utility to reshape the law as they think it should be in the future. But that judges should do none of these things in a democratic society. That judges should strive, even if humanly and imperfectly, should strive to apply the law as it is, focusing backward, not forward, and looking to the text, to the structure, and to the history to decide what a reasonable reader at the time of the events in question would have understood that law to be. Not to decide cases based on the judge's own moral convictions or the policy consequences that they believe might best serve society, close quote. Again, he's saying a judge is not a super legislator. If a judge wants to be a legislator, that's a completely fine thing to do. Take off your robe, resign your position, and run for the office so the people can decide whether to hire you or fire you. But if you're a judge and you have lifetime tenure, you don't get to make your policy preferences the will of the people somehow. Second quote, quote, when the political branches disagree with the judicial interpretation of an existing law, the Constitution prescribes the appropriate remedial process. It is called legislation. Admittedly, the legislative process can be an arduous one, but that's no bug in the constitutional design. It is the very point of the design, close quote. And third and finally, quote, to the founders, the legislative and judicial powers were distinct by nature, and their separation was among the most important liberty-protecting devices of the constitutional design, an independent right of the people, essential to the preservation of all other rights enumerated in the Constitution and its amendments, close quote. If my colleagues in this body are serious, if the 100 of us are serious, if we want to defend our role as legislators, if we're serious about doing our job as lawmakers, if we're concerned about overreaching executives, if we're concerned about the lack of accountability in the administrative bureaucracies of the government, if we honestly want to make Congress great again, we should start by confirming Judge Neil Gorsuch. Mr. Chairman.
Well, thank you, Senator, for your very thoughtful explanation. You and Senator Lee have laid out very clearly the Constitution, separation of powers, the proper role for judges, and proper role for members of Congress, and when one can't interfere with the other. And I think you've laid out very clearly, as I agree, that Judge Gorsuch fits in very well with what judges are supposed to do, what the Supreme Court's supposed to do, and obviously not legislate, because members of the judiciary doing that have a lifetime appointment. They can't be voted out of office, and that's why when people don't like what the Congress does, every 2 or 6 years, as far as the House and Senate are concerned, they get a chance to express that opposition and send somebody else to do the job, where you can't do that with whoever's on the Supreme Court. So I want to thank my colleagues for participating with me in this conversation that we've had about the separation of powers and about the thoughts of Judge Gorsuch on that issue of judges judging and not legislating. His record demonstrates a firm grasp on the separation of powers that animates our Constitution. He's an independent judge who properly understands the judicial role, and at a time when we hear renewed calls for an independent judiciary, I don't think we could have a better nominee to fit the bill. I yield the floor.